that ended up injuring an infant child.
Someone would have done this to your wife and your baby would have been in the car. What do you think that person should get? Prison time?
Good morning, sir. Are you Hakeem Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 25 DCCR 0843 with the first-degree felony offense of aggravated robbery. And Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at,
I think 600,000.
okay. And Ms. Malfino, you have a witness. Do you want Ms. Malfino to go first? Would you rather go first, or
No, I'll first, she can go first.
go ahead, Ms. Malfino?
Okay, Judge, just for purposes of the record, I would tender to the court just for ease of use, State's Exhibit Number 1, which is a probable cause affidavit in this case, and I will call Detective Kane.
Any it's in my file. Do you any objection
No
to,
objection.
States 1 is admitted for purposes of this hearing. Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead.
Could you please state your name for the record?
Dwight Dean,
And how are you employed?
Beaumont Police Department,
How long have you been in the city of Beaumont?
31 years.
You're a certified peace officer in the state of Texas.
Yes, ma'am.
And you and I discussed this case involving Hakeem Thomas as well as his co-defendant Tyree Hartley last week. And we're here in order to address the bond in this case. Can you briefly go over your involvement in the case and your familiarity with the facts in this case and why you think it's important that this defendant remains in custody?
My involvement is through Southeast Texas. I love that task force. We deal with auto murderers, and a new offense as was added to our penal code called jugging. We believe that this offense started out as a possible jugging on breaking into a car, and which ended up into injury with two of the guys involved. One standing here as well, that ended up injuring an infant child through coordinated efforts of us locally here in Beaumont, myself, officers on the street, along with deputies of the Chambers County Sheriff's Department. We're all involved to have these guys arrested.
So they did actually flee from this jurisdiction into Chambers County after this offense, which again involved an infant child in the back seat of that car being injured when they attempted to break into that car and retrieve the money that the child's mother had obtained from the ATM.
That's correct. The ATM of the bank, that the vehicle, the dad left the vehicle, and the mother and the infant child were in the back seat of the car. Not only did they break into the car with shattering glass on top of the baby and the mother in the car, with her continued efforts during the crime itself, they didn't stop. They kept on. Once they were successful, if you could say that, in any kind of theft, they did flee from here and were actually located, found in the same vehicle.
And did you subsequently with Detective Andrew learn that both of these defendants in this case had committed similar types of acts in various jurisdictions across Southeast Texas, Harris County, Fort Bend County, Austin, etc.?
Yes, ma'am. Some of it did happen that actual day, and then of course some of it was put together, trailed in the background, and those are after the arrest.
And is it your position, based on all of your years of training and experience as an officer here in Jefferson County, Texas, that to maintain the security and well-being of the safety of the citizens of Jefferson County, that it be best that pending prosecution of this offense, this defendant at least remain with some kind of a high bond from this court?
Yes, ma'am.
Thank you. I'll pass the witness, Judge.
Thank you. Mr. Lewis?
Yes, just briefly. Now, you said you were definitely part of the investigation of this allegation, correct?
That's correct.
Now, during your investigation, was it ever shown that a weapon or any deadly weapon anything was exhibited to the plaintiff witness? Or
Not that I'm aware.
So there was no weapon involved as far as we know?
Not that I'm aware of.
Okay. And as far as your investigation as it relates to my client, was it any statements or evidence that showed that he was involved with the actual breaking of that of the glass or possibly injuring the child involved?
Not that I'm aware of.
Is there any evidence that would show that they even knew it was an infant child in the car at the time?
No, it's not.
I'll pass the witness, Judge.
I've done further, Judge, just arguing.
Thank you, Officer Dean. Any witnesses, would you wish to call your
No.
client with regard to his financial status? Mr. Thomas, come back around. Best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Mr. Thomas, as far as your financial situation, you're currently in custody, correct?
Yes, ma'am. Yes, sir.
Now, do you have any money saved up that could be used for your bond?
No, sir.
Do you have any property that could be sold or vehicles or anything of that nature that could be sold in order for your family to come up with your bond?
No, sir.
Who would be responsible in trying to come up with the bond amount for you?
My mother and my wife.
Your mother and your wife? Have they been in touch with any bondsmen
Yes,
currently? Okay. And from the information you received, how much of a bond or commitment they will be able to make to try to bond you out?
The complete bond amount, between $70,000 and $100,000.
Between $70,000 and $100,000. Okay. Now, were you employed before you came to custody?
No, sir.
Do you have any employment or anything available to you if you're able to make bonds?
Yes, sir.
And what would that be?
Being a helper to my wife's father with his CDL truck.
Okay. And that will give you enough money to be able to take care of any pretrial conditions or anything you need to do
Yes,
with
sir.
your representation in this case?
Yes, sir.
Okay. I pass the witness in front.
Ms. Malfino.
Mr. Thomas, tell the judge a little bit about your criminal history, starting when you were a juvenile.
I have no juvenile record.
Were you in trouble as a juvenile over in Harris County?
No.
What about your theft, your state jail felony theft from a person, which is basically another way of saying,
That's
who
not
did you
juvenile,
rob?
no.
Don't talk over, okay?
I
Just
thought
wait
she
till
was-
she's finished
Yes,
talking so
ma'am.
the court reporter can take one at a time.
Yes, ma'am.
Where was that?
Go ahead, Ms. Malfino, you might want to read.
Your theft from a person, which is basically a robbery, where was that?
2021,
Where, in Harris County?
Rosenberg.
Have you been in trouble in San Antonio?
No, ma'am.
Have you been in trouble in Austin?
I have a pending case in Austin right now
For what?
for a robbery.
Do you have any kids?
Yes, ma'am.
Someone would have done this to your wife and your baby would have been in the car, what do you think that person should get? Prison time?
I don't understand this.
I don't have anything for you, Judge.
All right, anything else?
Nothing else for this witness, Judge.
All right, you may make argument.
Judge, as far as this case goes, you've seen that it is charged as aggravated robbery, but it's one where we don't have a deadly weapon involved or anything like that. The biggest issue, I think, with this situation, of course, is my client does have some criminal history and lives out of county. I believe there's already some bond conditions in place for him to have the GPS monitored and be able to go to be in Harris County, come back, of course, for court and everything. We are asking for a bond in between $75,000 and $100,000. I think that, including with the GPS monitoring and everything, would be enough to cover, one, secure his return to court, and also, of course, satisfy any public safety concerns while these cases are pending. He does not have a hold from the case in Austin, because I believe he's still on bond for that
I
situation.
find out while I'm in custody.
Right. So he is on bond for that, so he will be allowed to be released. My understanding, there's not been a court date set up there. We don't anticipate that interfering with us here as far as any type of issues. And from
When did you make bond on that case?
July, sometime in July.
Okay,
I'm not sure the exact date.
Okay, that's
sometime
fine.
in July.
all right, go ahead.
But from talking with his family, they have been involved with this case he has going on up in Austin, and that I think that actually will be resolved pretty quickly, and won't interfere with what we have going on here.
What, if anything, and Officer Dean may know about, I know you noted some other counties where there were some potential cases or issues. Do you have any other information on those?
I have reached out to Fort Bend, Judge. I have had difficulty in getting a final answer. A charge looks very looming. How they initially filed them, I think one of the impediments that I'm up against is in Harris County, Fort Bend County, that surrounding area. They have dropped a lot of stuff down to some very low amounts of time. So it looks like if an initial charge comes in as an aggravated robbery, it ends up 6 months later as theft from a person in the state jail. So that's really the totality that I've been able to.
Do you have any other
obtain from
additional
the
information?
co-defendant.
No, ma'am, that's exactly what I was gonna say. It looks like there's been some initial charges that were actual aggravated charges that were bumped down.
Okay.
And I would also ask if the court would take judicial notice of his incident of behavior report.
I will. I also have, and I think you guys should have received 7 pages of incident reports from the jail as well, which obviously y'all know my thoughts on that. And so anything else?
No, Judge, and the state does not object relief necessarily in this case, just not, I would ask that it remain in an amount at least above $350,000.
And Judge, if I may, to the jail incident reports, I think those were like early on when he got into custody. Of course, me and Mr. Thomas did speak about those and how, of course, he should conduct himself out there, and I don't think that he has had any other issues since that conversation.
I guess my concern, and I understand from the probable cause that the allegation is that Mr. Thomas was the driver of the car, but I don't know that that makes it any better whatsoever, because it doesn't sound like there's any evidence on why he and Mr. Hartley were in Jefferson County, if they're from Harris County and that's where he's going to live, why they're in Austin, why they're wherever they are, other than to come into our county and break into people's cars or jug, which has become a huge issue. And so based on the evidence today with regard to this specific offense, based on the jail incident reports, based on the information received through, again, take judicial notice of the court's file, the magistration information as well, the fact that there is at least one pending case that is similar, others that sound similar, just with some different outcomes, I don't think it is in anyone's best interest that Mr. Thomas have any relief today, and so I'm going to deny the motion to reduce the bond. We will reset the case and for an announcement and see where we get. All right, thank you, sir, for being here, Mr. Kane, Officer Kane. All right, we, the jury, find the defendant, Romeo Randolph Johnson, not guilty. Have a seat, sir. All right, let the record reflect the jury is seated, state's attorneys present, defendant and defense counsel are present. Before I get the verdict form from the jury, for those who are here in the courtroom, I'm sure whatever happens could be potentially emotional, I'm going to order everyone. There will be no outbursts tolerated. Just let us read the verdict and then we'll go from there, okay? And so I would ask the foreperson, has the jury reached a verdict?
Yes, ma'am.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am.
Thank you. You can hand it to the bailiff. Mr. Johnson, if you please rise. We, the jury, find the defendant, Romeo Randolph Johnson, not guilty. Have a seat, sir. So, Mr. Johnson. Mr. Johnson, you've been acquitted of the charge as alleged in the indictment by a verdict returned in open court by the jury. From this, Mr. Johnson, I need you to pay attention to me for just a second, please. Okay? Have a seat. Have a seat. All right. So there's still another case pending, and so we'll get that set for trial as quickly as possible. You are still incarcerated under that case, and so you'll be able to go back with the bailiff now, and then I will give you your instructions in just a few minutes, all right? All right, you can take him back, please. And so, ladies and gentlemen, while they're doing that, what this means is that the case is over, obviously. I'm going to have everybody leave the courtroom, and then I'm going to come down and visit with y'all for a little bit and give everybody time to clear out. You can answer questions and things like that. So just stay put, and I'll go through those instructions with you and relieving you of your instructions and things like that. All right, Mr. Johnson, you need to go with the bailiff. Mr. Johnson, go with the bailiff. Thank you.
This in there.
We'll see. Good morning. You're Zully Valicia. And Ms. Valicia, you were previously in court and entered a plea of guilty to burglary of a habitation, a second-degree felony. This is 24 DCCR 1364. The agreement was for a cap of 7 years in prison. I've received the pre-sentence report and reviewed it. Has everyone had an opportunity to review it?
Yes, Sharon.
Yes, sir, we have.
Any additions or corrections?
I've reviewed the PSI with Julie. I know that obviously her version, the court has questions about that, and so I would allow her to address that if she does wish to move forward in hopes of obviously us arguing for the probation.
So here's the thing. If you say you didn't do it, you don't get to say I didn't do it, but please give me probation, because then you're not accepting responsibility. So either you did it, what they charged you with, or you didn't. And doing it doesn't mean that you participated fully, and I'm sure Ms. Holmes has explained to you the law of parties in Texas and what that means. But if you say somebody took your car and you weren't even there and you had no idea of it, then that's what juries are for. Because you are about to take the chance, if we go forward, of me sending you to prison for 7 years. Me possibly giving you probation. But I can assure you that you're not going to get any kind of help from me if you get up here and say, well, I didn't really do it, but come on, give me probation. Does that make sense?
Yes, ma'am.
So tell me, if you want to go forward, tell me exactly what you did, what your part of this was.
I was aware of what my car was going to be used for. I didn't participate in the act, but I know.
So you didn't drive your car?
No, I did not. I did not drive it at the scene where it happened.
Mr. Nichols, it appears that the,
If I'm explaining myself, right?
I think what she was trying to say, Your Honor, she wasn't present at the scene of the burglary, but let them use her car and I guess drove them close by. Because we know she was pulled over driving that vehicle on the way.
I mean, there's cameras from Lieutenant Hudson's cameras that confirm that you were driving when you were stopped
Yes.
with the other guy seated in the
I
front
was in
seat.
town. I was in town when it happened, but I was not at the scene.
So, yeah.
So when did he get in your car?
When they brought it to the crime scene, but I was not at the crime scene. I was,
I'm very confused.
So she drove here to Groves. She drove into town. She was aware of what was going to happen.
You weren't aware of it. You drove in to be a part of, you knew. I mean, there's saying I'm aware
well,
of whatever.
can
Y'all
I
came into town with,
can I rephrase myself?
you
Why
probably
would
should real quick because
I
hang
was
on.
not- I was
Also,
not at the crime scene.
hold on.
Yes, ma'am.
Because y'all came into town with radio jammers and fully ready with medical mask and face mask and all this stuff to come in from out of town to do what you did here in our town. And so you weren't just riding along and then they said, oh, by the way, sorry you came with us, we're gonna do this.
Okay, well, I drove because I'm the one that had the license, so in case we got pulled over.
Okay,
But I was not at the scene.
so you brought them to do the
Yes, ma'am.
crime.
Yes, ma'am.
It's not that hard to say.
Yes, ma'am. I didn't know how to rephrase myself, I'm sorry.
All right, Ms. Holmes, go ahead with argument.
Yes, Your Honor. She does not have an extensive criminal history. As you can see, there is one prior, looks like a theft of property, which she received 6 months state jail. And then there was a federal case as well back in 2020. Ms. Zuli is currently employed and working. She would like the opportunity to continue that with probation. She does care for family members as well, Your Honor, for a household. As indicated in the PSI, they do have her at a low risk level, which I believe is indicative that she would be successful on probation if given that opportunity.
I think the 7 years is appropriate. I'll note for the court, the co-defendant got 10. At least one co-defendant got 10. I'm not sure on the others. But I think 7 years is appropriate, and given the instance of this case.
How'd y'all pick this person?
Sorry.
How did y'all pick this house, this person to come in?
No, like I said, the only reason why I came here was because I had the license. So in case they got pulled over, they didn't have a way to prove their citizens. So I was just like the one that drove into town. I don't know about the.
And if I can, 2 of those individuals have fled the border. They were not legalized, so they probably will never be found. So there were 2 other individuals involved.
Right.
In which she has tried to get contact, so that's the reason why they were involved. She was the driver, but they have since fled the country. They're not coming back. That actually went into the house. There was only one that was caught that received the 10.
Mm-hmm.
So I think that's what she's trying to say is she was driving because they obviously did not have the credentials to do that, and we don't know where they are.
So do you know why y'all came to this house?
I have no idea. The only reason that I came into town was because I'm the one that had the license. So in case they got pulled over, they didn't have a way, to prove their legal
How many
status.
other times did they have you drive you to other places?
No, that was the only time I did it, and I regret it. It was crazy.
Your Honor, if I may, I had the co-defendant's case. The victim in this particular instance was a local business owner, owned a donut shop. They also owned a donut shop and forgive me if I'm off on the exact city, I think somewhere in Humble, or nearby in Humble. That business, their home in that city was also burglarized.
Right. So, right, thank you,
I
Mr.
cannot show you I was not involved in any other situation that had to do with them. It was just a one-time thing.
How did you know these guys?
Well, basically, one is my barber. The one that's doing time, he's my barber.
He's your brother?
Barber,
Barber.
yes.
What about the other two that took
No,
off?
I never knew them.
So where do you live now?
I live in Houston, Texas. Yeah, Houston, Texas.
Do you work?
It's my
Where-
hours, 50 hours a week.
For what? For who?
It's integral. It's basically for the state. I get paid $25 an hour.
To do what? I'm sorry.
I don't know how to describe it. It's like solar panels. Like, it's for the state.
Okay.
I have evidence as well.
You have what?
Evidence that I'm working there.
Okay.
Before that, I was working at a car wash, but they offered me more there.
So I don't disagree with Lieutenant Hudson or with Mr. Nichols, because of what happened and the targeted way that this happened. It does appear that the guys were probably in charge of most of this. You made a really, really stupid decision.
Yeah. And I regret it.
Yep. All right, what I'm inclined to do, because what you're charged with is a second-degree felony.
Yes, ma'am.
So the range of punishment is up to 20 years if you went to jury, or all right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're going to be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. So let me explain what that means and why that's good for you, but probably more so for me, and why I'm doing this. So a deferred probation means you don't have this conviction on your record. But what it also means is if you violate any condition of probation, you will be brought back into court, found guilty, so you have the felony conviction, and that cap of 7's gone. I have the full range of punishment between 2 years and up to 20 years. And certain cases, for whatever reason, the fact that this one, I remember it from Mr. Coleman's case, from the co-defendant. I'm likely to remember it. It's never good when I remember things, okay? And so I'm going to order also that you obviously have no contact or communication with any of the co-defendants. If they've fled the country, whatever, that's, if they come back, if they try to contact you, you cannot have any contact with them. In fact, I'm ordering, if they contact you, that you contact your probation officer and law enforcement and let them know any information that you have about where they are. You will be, I want her on the medium-high caseload to start off with. It means you're going to be reporting more often, making sure you get off on the right track.
I work like an hour from my house, so I leave the house at 2:30 and come back home at 2:30 in the morning.
So talk to probation. I want you to work, okay? And so you need to get them documentation of your schedule, because there will be a curfew except for employment purposes. You'll be required to report in Harris County, but you're also going to be required to report by mail or online here. So you kind of have double duty. You've got to do it all. If you don't report by mail or online here, it's a violation. If you don't go in person there, it's a violation. If you don't give them proof of where you are when you're supposed to be, it's a violation. If you test positive for any drugs, whatever it is, you're going to be on a high caseload so that I know, at least for some time, that you're doing exactly what you're supposed to be doing. And if you don't, you will be right back in here. Do you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you.
You shot at a car going down the interstate because they cut you off. Good morning, you're Charles Newman? And this is 25 DCCR 0545. Mr. Newman was previously in court, entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. Has everyone had an opportunity to review the pre-sentence report?
We have, Your Honor.
Are there any additions or corrections?
Not looking at us. The only addition, Judge, is after speaking with the complaining witness, we would request $1,653.75 in restitution.
We are not opposed to that.
1,653.
And 75 cents.
75. Mr. Newman, if I test you this morning, you gonna have anything in your system? Let's double check that first. Have a seat in the jury box. And if you'll
Yes, just give me a couple minutes.
work on
Get
Mr. Hebert,
in
please.
here.
Okay. Okay. We're back on the record. Excuse me, cause number 25, DCCR 0545, and Mr. Newman's here for sentencing. Mr. Newman tested positive for THC, which obviously gives me some concern.
Which, just to briefly address that, he took a drug test just the other Thursday. That was for work.
No, that was just to make sure like I was doing good and everything. I passed. That's why.
Just to make sure you had everything out of your system
Right, yes,
before you
ma'am.
came to court?
Right. Well, not like I just wanted to make sure that I was doing like.
He had surgery a month ago.
And then I had-
taken
Stop
narcotics.
talking over your attorney. Let him talk.
He had surgery a month ago. He took narcotics as part of that. He has a prescription for that. But he took a drug test just to see if anything was going to show up. Nothing showed up.
Well, THC isn't have anything to do with
That is
a
correct.
surgery.
That is correct.
He's admitted that he uses marijuana. That's
right.
why I had him tested today. So at some point, you used marijuana, and you clearly were making sure it wasn't, if you had a prescription for narcotics, that's not what you were worried about. You were worried about testing negative or positive for marijuana because you admitted to the probation department that you use. And so stop. Take responsibility.
Yes, ma'am.
You shot at a car going down the interstate because they cut you off.
Yes, ma'am.
You barely missed a person in a car because you got pissed that they cut you off. And you're going to sit here and argue to me about using marijuana? I mean, this is crazy. What you did is crazy. The deal you're getting is amazing. And I would think you would come in here absolutely clean, not hoping you're clean and testing positive the week before because you might have used something that might not be out of your system, which is where we are today. All right, anything else before I sentence Mr. Newman?
Judge, I just point out a couple of things that are in the PSI. This is a severe situation, but it's certainly out of character. Mr. Newman has never really been in trouble of any kind before. So this is definitely certainly a one-off. He's always remained employed, had good employment. He did lose his job as part of this case, but he's had surgeries recently and he has work lined up. So he is intending on continuing to maintain the normal life that he's always held, other than this particular incident. Obviously, if marijuana use is a concern, if he can't stop using marijuana, they're going to figure it out at probation, whether that's drug testing or a patch or whatever the court decides is necessary for that. But it's not using, worse drugs that would be even more concerning considering this case. So we're just asking the court to follow the deal and impose whatever drug conditions the court deems are necessary.
Mr. Smith, anything else?
No, Judge.
All right, so Mr. Newman, what I'm going to do, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $1,000 fine. You're ordered to pay restitution in the amount of $1,653.75. You will be ordered to enter and successfully complete the JCDI program, which is an intensive outpatient treatment program. Obviously, if you're using this close to court, you're going to get some treatment to make sure you're not. You will be required to wear a drug patch until further order of the court. I am also going to order that you serve 15 days up front in the Jefferson County Jail. And so you'll talk to probation today. You will go into custody. And this is just too serious of a case for me not to make sure you understand some consequences of your actions. To be coming in here for shooting at someone in a car, testing positive, is just, it's not okay. And you need to understand that. So this is still an amazing opportunity. You don't have a felony conviction on your record. So if you successfully complete the probation, and Mr. Galmore's right, this is apparently seems to be very out of character, but it's so serious that it's just something's going on, and we're going to get that figured out. And so if you do everything you're supposed to and you're successful on this probation, the case gets dismissed at the end. You will never be a convicted felon. But the other side to that is if you violate any condition of probation, you will be brought back into court. You could be found guilty of the offense, and you could go to prison for up to 20 years, anywhere between 2 and 20 years for this offense. One of the things that makes me a little more comfortable, I guess, you're very lucky that the victim of this offense, number one, didn't get hurt, and number two, is in agreement with you getting this help and being on probation and making sure you follow through. So you should be very appreciative of that. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You can go with the bailiff. Probation will talk to you in just a few minutes before they take you back. Good luck to you, sir. He beat her. You admitted to beating her. There was a no contact, and now we have another baby. So obviously there was contact. Good morning, sir. You're Brandon Bell? Yes, ma'am. And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
I have, Your Honor, in addition to some medical documentation that Mr. Burbank has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. What should it have?
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
I don't know what you're talking about. Yeah, I mean.
These are medical records from Spindletop.
Okay.
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working.
Okay.
Which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you recall the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know that's been a concern, but I had some difficulty with that portion of the case.
Okay.
And if the court would also remember, she was expecting another child, they are expecting another child. And
Okay.
She's
So what,
also-
go ahead and make argument, and then I'll,
She's also controlling the checking account. He's getting settlements, and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, I have some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was, he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there's some program that he can have that's outpatient, to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report, he is reporting. It's not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not he can do it. And you couple all that, I've had extensive conversations with his wife. I've tried to tell her the way it has to be as of yesterday. We've talked over the phone and the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8, Ms. Lopez?
I mean, I guess it kind of depends on the
Just in the context of what she has to say.
yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair? Affirmative recommendation. But Ms. Lopez is identified as defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition 9. Can you explain that to us?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that they are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation center.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like spindle top, yes, you know, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that that may be a recent thing. And so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include in the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, etc., regardless of whether or not they mutually agreed to do so. And I believe your recommendation is very well thought out and very well put in the updated PSI. Do you have anything to add to the report?
I do not at this time.
You have some questions.
I have some questions. Mr.
Yes, sir.
Ma'am, did you ever get his records from Sweatpants?
I believe so, yes.
And is he under medication?
Not during the time of all of this taking place. I know that since he was out on bond, I believe he went to Spindletop as of August 11th, and that was when he began having his medication the way he was supposed to.
In your report, you stated in the first or second paragraph that while the defendant does report as directed, he has made basic efforts towards paying his fees, correct? So he has been reporting to you.
Correct.
And then you also started receiving phone calls from the victim. Did you have any dealings with the victim at all? Were you here the last court hearing?
I was.
She didn't act very rational either, did she?
Not often, no.
And do you realize that they are expecting another child?
Yes.
And how many other children do you remember?
I believe they currently have 3 children together. I believe this is the 4th.
If I told you that there was a settlement to Scott Brown in reference to the motor vehicle accident that took his leg, you wouldn't disagree with that.
He told me that at the jail when I did my PSI update.
And he's getting monthly, I guess, settlement checks or quarterly settlement checks, in which the wife does have access to his account.
That I don't have any knowledge of.
You did also receive telephone calls from his mom, correct?
Correct.
And basically she said that he's talking out of his head, he has mental health issues, right?
She did at one time, yes.
She didn't know, well, has to be between April and now, right?
Yes.
That's what he put on.
Specifically whenever he was out on bond.
Okay. He did appear or direct to be kind of delusional state, correct?
Yes.
Unable to remember reference to taking medications or injecting, so he was on some type of medication, correct?
Correct.
And that one of his problems is that he has to learn how to remain on his medications in order, from Spindletop, in order to, I guess, try to live life normally, correct?
Correct.
That's nothing further.
Anything else, Ms. Malfino? I don't know yet what I'm gonna do, but if, is there any reason based on the injury that Mr. Bell could not go to special needs safety? Is that something that would prevent him from going?
I do not believe so.
You don't think so? You don't think so?
I think there are people that have gone to Spindletop that are
Sure.
in wheelchairs and things of that nature.
Yeah.
I said Spindletop, I'm sorry, safety.
Yeah.
So I think he would still be able to go. I think it would be under special needs.
Right, that's what I would,
Yeah.
if that were an option, it would be special needs, because that would address both
That
of the,
addresses mental health also, Judge.
yeah, that's what it's for. I mean, and here's the thing, I think a lot of the mental health is because you're using synthetic marijuana. I mean, that's gonna, so. Ms. Malfino, anything else?
Judge, I think you have a lot of information before you end your decision. I do think it was important, and I didn't want to hide behind the fact that we have had the issues with the complainant, and she did come and testify.
And that's the only thing that's keeping me from doing probably what needs to happen.
But I don't have an interim update with respect to her.
Have you heard anything?
I have not heard anything since all of this happened. The reality is she's called me multiple times and complained and said that Brandon's here and she wants him gone. But Ms. Lopez, please don't send him to jail. She is very back and forth about it. My largest concern, Your Honor, is that the offense that the defendant is on probation for is extreme. And my biggest issue, in truth, is the fact that Mr. Bell does not take any responsibility for any of it at all.
I don't disagree.
Can I just have one question, Judge? Did this accident happen after
When did your accident happen?
November 4th.
of last year?
Yes, sir.
Of last year?
So all this has happened since he's been on
No, but
probation.
Was this
No, prior.
before, was that prior
His
to
accident
his
was
accident?
prior to when he was placed on probation.
Right.
No, but how about the incident itself? That is
Oh, the
probation.
underlying offense?
Yeah,
April of last year. So the underlying offense was prior
prior to his.
to the injury. But the injury was prior to probation, where he's still, I mean, regardless of the, you can still do things to injure someone, to harass someone, to put someone in fear with or without a leg. And that's what he's done. That's what you've done. Still make babies with her. I mean, I don't know. I mean, that she was pregnant. The whole point of this is you beat the crap out of her when she was pregnant, and now,
Third child,
and now we've got the fourth.
correct.
Judge, would you like me to do a bailiff's call for her and see if for some reason she showed up today?
Sure.
Or needs to speak with her, Adriana Bell?
Can we do a call for,
Adriana Bell?
I don't know if that's gonna help either, though. We've done that before.
And I don't know if it's a situation where it's the court needs to protect somebody from himself.
Do you want to reset it so I can?
I don't think it's gonna matter. I mean, she's been here before. I've ordered,
No response,
I think I have her mother's here.
but they had there was a no contact, and now we have another baby. So obviously there was contact.
Can I address, from what I found out, Judge?
I don't need Snickers from the gallery.
I'm not calling them as witnesses, but every time they got mad at each other is when she got on the phone.
But she got on the phone, but that's him blaming. He beat her. You admitted to beating her. So she's probably scared when he gets mad. And then it gets okay, and then it gets mad. And he doesn't know how to get mad without beating the crap out of her.
I didn't get that indication, Judge. She's been to my office every other day. She's called. I mean, it's really,
I'm not in disagreement that Ms. Bell is also the problem, but my biggest concern here is their children.
separation.
Yeah,
I don't care if they stay together or not, admittedly, frankly.
yeah.
I'm more concerned about the children involved in this case because of the violence that they're being subjected to. Whether or not the two of these adults can reconcile is between them, but there are children involved that I am extremely concerned about.
I agree. All right, here's what I'm gonna do. Mr. Bell, I don't feel like I have any other choice at this point but to protect your children and to protect your, I don't know if y'all are married, girlfriend, wife, mother of your children from you. I understand the mental health issues. From what I can tell, most of those are self-induced because you were using K2.
It haven't been an incident since I've been on probation.
That's not true.
I haven't had no abuse case since I've been on probation.
Okay, so you haven't abused her, but you weren't even supposed to be around her. I gave you don't talk over me, because y'all I told you when I put you on probation that she cannot give you permission to violate my order.
Yes, ma'am.
She can't say, it's okay, come on over.
She came to my house. I was staying in the house. She wasn't staying there.
Lock the door, kick her out. You're the one that's gonna go to prison.
She said that she called the laws to kick me out, and you said it still was an issue. She called the laws to kick me out. My mama came and got me, and I've been staying with my mama. I ain't been around her. She been calling the laws on me every time she come to my house. I paid $100,000 cash.
Why are you still having sex with her and having babies?
That's early on.
Early on when? We've only been doing this for 6 months. You've had 6 months, and all this has happened in 6 months on probation.
It happened 3 months because she finna have a baby next week. 3 months before I was on probation.
So what if she shows up at your mom's house?
She's not gonna show up over there. She know her and my mama don't get along.
Probably for good reason.
I would represent to the court that there is a problem there, Judge, because even when we talked about possibly with him seeing the kids without her at mom's, and that wasn't a possibility. It's something between her and the mom, his mom. And I know his mom, his brother has gotten in trouble. She has a very stable job at a bank. She's very straight-laced. His brother was the one in the West End that was burglarizing cars, and the owner stopped him and shot him about 8 times on the road and left him there. But she is very straight-laced, and she just couldn't get off of work this morning because of the bank.
So,
But he needs something, Judge. I mean,
well, but we tried to give it to him.
well, I'm talking about.
I have money now to pay for my battery class too. I have money to pay for my battery class and pay off my probation.
I'm not as worried about you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put him on a GPS and reset this for 60 days?
No, I'm going to make my decision today. Because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not gonna get out and see how we do and take that chance without having some kind of treatment up front. I don't know, y'all hold on a second, just don't take them far. For some reason, Anna, when I pull up the version that should have my notes on it, it doesn't have anything on it. All right, Mr. Burbank, Mr. Malfino, and sir, again, you're Brandon Bell. And so, well, just to get us back where we need to be, everybody's reviewed pre-sentence report, made argument. I want to go back just one more time and see. I know, Mr. Burbank, you're asking that I continue Mr. Bell on probation. With treatment. I know Ms. Lopez has made her position very clear. Ms. Malfino, what is the state's position?
Judge, I certainly have ultimate respect for Ms. Lopez's position. She knows the defendant and what she's been dealing with a lot better, probably has a slightly different perspective on the kid other than what I do, so I certainly defer to her opinion. I also at the same time agree that probably the safety special needs to address that synthetic marijuana issue may be relevant. Has he had that opportunity in the past with some other charges? Yes, very well so.
So what?
Revocation may be appropriate, Judge, based on the underlying offense itself. If it is not, of course, we would be of the opinion that if he goes to that and violates zero tolerance in any way, shape, or form, we ask for the max.
Okay, I'm just reminding myself also, so what I did not do previously was go through and take a look at that old pre-sentence report, which has the criminal history, which includes
Several sentences in prison.
already been to prison, given an opportunity on probation in 2020, which is not long ago, 5 years ago, revoked and sent to prison for 2 theft cases. One was a TDC case, given 3 years. And so pretty much gets off parole barely and commits this offense, gets the opportunity at probation, and we're where we are now.
And he does have an extensive juvenile history, you will see in misdemeanor as well. And again, that's why
Yes.
I wanted to let the court know that. An underlying probation offer was made with the issues with Miss Adriana Bell that the court is obviously aware of by this point.
Okay, I am looking back at history, juvenile history, going back to 2013. Assaults, violation of court orders that look like it should have ended up in Texas Youth Commission. For some reason, they kept putting you on probation all the way until 2018, when you apparently become an adult. Then you start getting felonies and misdemeanors, get probations on all of those. Those are revoked. You beat the mother of your child while she's pregnant. You get a 5-year deferred probation, and you don't take advantage of that probation. I feel like at this time, what Ms. Lopez said is absolutely correct. You are a danger to your children, you're a danger to the mother of your children, and in my opinion, you're a danger, a menace to our county, and have been since 2013.
Just one thing, do you know when his mental health was discovered?
I wasn't.
Probably when he started using synthetic marijuana. So at this time, I'm going to find that you entered your plea of true. So you were previously in court, entered pleas of true to counts 2, 3, 4, 6, 7, 9, and 10. And then today, I am going to make a finding of true to counts 1 and 8 based on the testimony of Ms. Lopez. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon, I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And I'm going to hand you, and y'all need to sign this, trial court certification that shows this was not an agreement. There are some rights to appeal. You can talk to Mr. Burbank about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you. Hang on. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. You need to sign that, and then I'll get you a copy of it, and then you can go back with the bailiff. I do think that's fair, and hang on to, Mr. Bell, I can go up to 20 years today. See, this is, talk to Mr. Burbank about that.
Is it?
Yes, sir, thank you.
Can you explain to the court what those first few days were like, not knowing where your mom was or what had happened to her?
It was terrifying. It was shocking because I had just talked to her. She was just on the phone with me, and she was excited for our plans. She was joking with me. And so I was lost. I didn't know what to think.
At this point, you're 15 years old?
Yeah. 15, my mom is the person that I go to for everything. No siblings, it's just been her and I. So, lost, very lost.
As those days turned into weeks, and then months, and then years, can you tell us what that was like?
You know, the first year, I think I threw myself into anything I could to try to get through life, to not think about the fact that she wasn't there. But then you go home and you don't go home to your mom anymore.
Where were you staying?
I was staying with my Aunt Susan. And so life is different. It looks very different. We spent a lot of time going to the police station, a lot of time doing vigils and posting posters and anything that my aunt could do to try to figure out where she was, what happened.
You said y'all put up posters, and was there physical searching going on, people looking for her?
Yes.
Were there billboards?
There was a billboard.
Do you know who put that billboard up?
Terry Rose did.
Terry Rose put up a billboard to help find your mom.
Yeah. To find my mom when he knew where she was at.
So, about how old are you now?
I'm 42.
And a couple of years ago, when the investigation gets reopened, and there's progress being made, and then David Wiley finally comes forward and says, here's what happened. I'm sure you were, every step of the way, following what the police were doing.
Absolutely.
When did you find out they had found your mother's body, or her remains?
June 13th, 2024.
What were you doing?
I was actually driving to Belmont. I knew the search was going on. I had been in constant contact with Heather Wilson, and I actually was driving very close to Lindbergh. I just gotten off work early, and she called me and said, hey, we found human remains. And I just screamed and pulled over my car.
For 25 years, she was missing. Now she's been found. After they recovered her remains and did the testing, the DNA testing, and said, yes, we know this is Kimberly Langwell, we're able to have a funeral. When was that?
Say that again, I'm sorry.
We're finally able to lay her to rest.
Yes, sir, we were.
When was that?
That was October of last year.
Of 24.
Yes, sir.
Tiffany, you know, we have essentially an agreement where Terry Rose pled guilty to the murder of your mother. And as part of that, Judge West can sentence him anything up to 40 years.
Yes, sir.
What are you asking the court to do today?
I would like him sentenced to at least 40 years. I think he deserves that.
And you and I've spoken, there's not a number that really makes this right, isn't it?
No, there never will be.
Thank you. I'll pass it.
Thank you.
Thank you. Any questions, Mr. Burbank?
No questions.
All right, thank you, ma'am. You can step down.
Thank you.
Let me call your next witness.
Your Honor, I'd like to publish State's Exhibit 1 at this time.
Sure.
No, just a portion. We can save time, Judge, because I was going to ask that be published in its entirety. I can redo it.
How much is it? How long?
It's a 15-minute phone call, Your Honor.
Okay.
If you want me
You
to
can
play
play, you can play your part now, and then you can play your part in a minute, or you can play the whole thing, whatever you want to do. I'm fine either way.
This is a prepaid call from
Terry Rose.
Your call has been accepted.
Hello? Hey, I don't know. Maybe she just don't want to have to deal with this trial and try to hide and stay away from it because she don't.
Your Honor, for the record, I have forwarded to just past the 10-minute mark on this phone call to play my portion.
Okay.
Like all this stress and shit. Well, I don't know. I'm gonna just let it go for a while. My trial is, my pre-trial is December the 8th. I'll go down there and hopefully they'll make me an offer. If they will offer me 25, I'll sign on that and we'll be done. If they try to offer me anything else or they don't offer me anything else, well then we'll just go to trial. Yeah. Because, trial is like 5 to 99. Okay, I could get as little as 5 years or as much as 99. They're not going to give nobody 99. I'm not like a psychopath, sociopath, crazy ass, I'm not none of that. I had a bad day, I dealt with it wrong, I fucked up, and I'm got to deal with it. So, the only problem is the judge and the prosecutor both the judge is running for re-election, the prosecutor's running to be a judge, so they're going to try to use my shit because it's so high profile shit to make them look good. So I'm pretty sure I won't get much of an offer at all. Because that 40-year offer was like an insult. I'm 68 years old. 40 years, you got to do 20, so I'd be 88, and then I go before the parole board, and Tiffany's going to be there to say no, and then I got to wait another 6 months and go again, possibly. I'll be fucking 90 years old before I get out, and then I got to deal with parole for the rest of my life? Oh, fuck no. No, I'm sorry. I'm not accepting.
Oh, no, man. She's in her 40s. People die in their 40s and 50s all the time.
That'd be sweet. Yeah, that'd be sweet. I will pee in a cup, send it to y'all to pour on her grave. I'd do that. You little lying bitch. Oh, yeah, I'll fix her right up. See, if she would have been honest and said, look, I was out messing around on you, I could have just walked away, not had a problem, and none of this shit would have been a problem. But no, she had to keep her mom's secrets. I didn't know. I kind of suspected one, but I didn't know if she had a fucking heroin. But anyway. So I don't know.
State of Texas rests, Your Honor.
Thank you, Mr. Burbank.
Your Honor,
Thank you, Mr. Nichols. Mr. Burbank?
we rest. I didn't know what section he was going to play, and I'm fine.
Is there more that I need to hear?
No.
All right, so no other witnesses? No witnesses, Mr. Burbank?
No, Your Honor.
All right, Mr. Burbank, you may make argument.
Hey, police court, counselors. As you well know, we've been doing this a long time, Your Honor. I guess I longer than you, and there are no winners in this case. Problem with this case is that if it was, I guess, called upon or detected or police were notified and she was found, it might have turned out differently, or there were other facts and circumstances that might have arose. There's a couple of things I'd like you, but it didn't. And no matter how you look at it, Your Honor, if there were facts and circumstances at the time of this incident, they are bygone and they're not here anymore because of the 25 years of where that person was, Kimberly was placed. And that's the sad part about this. When you look at this and you look at people in reference to representing him as a defense attorney, I look at things. For instance, in State's Exhibit number 1, I wanted to make sure that the court realized that no matter what, he was not talking about Kimberly Langwell. He was talking about the daughter. And as the court is well aware, there is also a civil trial going on in reference to, with her family.
So dumping pee on the grave was whose grave? Who's he talking about?
He's talking about the daughter.
What
and
daughter?
not her, not Kimberly.
The daughter's alive.
I know, they were talking about it.
Okay.
Because, and it had to deal with the civil case that's currently pending.
Okay.
It was not,
Okay.
it was not for Kimberly. And it's reflected in that, Judge, in reference to things that supposedly she should have done about telling about Mom. You have a gentleman here, though, unlike a lot of other cases that you see before this court, that has no record. He has gone 68 years, and there is no record. There is nothing there that says he's lived a troubled life, in the sense of that he's had a secret. He has, and I asked the court to take judicial notice of the 2 letters that were written, one from his aunt and one from his daughter. One of the things that I believe that was brought out, he is relieved at what happened. It has been eaten on him, just as Mr. Riley. He's sorry for what he did. He's tried to explain within the PSI and in reference to the version that he has given. I can't tell you what, if any, consideration that you may be able to give him based on the ultimate facts and what's happened. But you have an individual that has not been in trouble, that has been employed, except he kept a secret. And he kept a secret to the detriment of a family that was grieving at the time and wanted to know where their loved one was, especially a 15-year-old girl, and that he can't erase. I would ask for any consideration, if any, of course, of his age, because of the nature of the offense of being 3G under the Texas Code of the Penal Code and Texas Code of Criminal Procedure. So any consideration that you might give, but there's a cap for you. Thank you.
Thank you, Mr. Burbank. Mr. Nichols, can you play that again for me, please? I just want to make sure
I can, Your Honor. I'll represent to the court. He's not talking about Kimberly Langwell.
Okay.
And I'll make it part of my argument.
Okay, go ahead then.
The phone call you heard, Judge, was him talking about how it greatly inconvenienced his life to have to deal with the parole board should he ever make it that far. And that no doubt Tiffany McGinnis would tell the parole board not to let him out early. That's what he's complaining about. And his son, who's the other end of that phone call, mentions, well, maybe something will happen and she'll die. She's in her 40s. And his response to that is, I would gladly pee on her grave, Your Honor. And the reason I play that, along with a lot of the other evidence we heard today, shows this man has no remorse, no feeling whatsoever for what he did to Tiffany's mother and what he's done to this
Don't talk,
family.
if you want to testify, you can get up here and testify. Otherwise, you have refrained from doing that, and so stop talking.
And on that call, he blames a then 15-year-old girl for not telling him that her mother had moved on. And that's sick and twisted, Your Honor. No more sick and twisted than living in a home with your murdered ex-girlfriend under your floor. A home that he later shared with his common law wife. A home that no doubt people came and went in for the last 25 years. With Kimberly Langwell buried in a shallow grave under a bed. Every step of the way has been a slap in the face to Kimberly's family. Every step of this is just inhumane. To go there the next day and open up the car for them, knowing what you did. To tell somebody and expect them to keep the secret for 25 years. To put up a billboard and pretend you're trying to help find her it is vile, it is inhuman, and it is not worthy of any consideration from the court, Your Honor. The cap is 40 years because of his age. And I'm asking the court to enforce that full 40 so Terry Rose spends what's left of his life behind bars, Your Honor, because that's what he deserves. Thank you.
Thank you, Mr. Nichols.
You want us to rise, Your Honor?
I don't care. It's not often that I'm at a loss for words, and honestly, it's because I have too many words. And anything I say is not going to help Tiffany and her family other than getting this over with, which is why I pushed this to get done today and not wait until the end of the year or the first part of next year. But there's just certain things that I can't even look past to not point out. The fact on that phone call that you said you're not a psychopath is just beyond me. Who isn't a psychopath that kills someone that they once cared about and buries them in their house and lives on top of them for 25 years? I would think that's the definition in Webster's dictionary of a psychopath. It's not a bad day. It's a bad 25 years for her. I mean, it's the nonchalantness about how you spoke about this told me way more than I really needed already with what I had. But that is just the fact that you think for some reason that me running for re-election or Mr. Nichols running for election has anything to do with what we're doing today. It does not. You can ask anybody here, any of this law enforcement. I've never made a decision because of politics, and I never will. And Tiffany's right. 40 years isn't enough. There is a part of me that wishes I had not accepted this plea agreement and that we had gone to trial last week. Because I do think a jury would have given you life for 99 years. I actually do. If they had heard that, you would have gotten that. And the fact that you thought you wouldn't is the most narcissistic thing I think I've ever heard in my entire life. So, I mean, there's just so much more. The billboard, I mean, it's insane. It's psychotic. That's what it is. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I hope that today gives Tiffany at least some final closure on all of this and her family. I'm going to sentence you to a term of 40 years in the institutional division of the Texas Department of Corrections. If I had 50, I'd give you 50. If I had 60, I'd give you 60. Whatever it was that the cap was going to be, after hearing all this, it would have been whatever it was.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was an agreement, so you have no right to appeal, which also is one of the only reasons that I accepted this plea agreement, because that does make this final. So there's no appeal, there's no chance of anything happening, it's over. I highly doubt that this matters, but I am required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about that, you can talk to Mr. Burbank about how long it is or the eligibility. Again, I don't anticipate that being an issue. I want to thank every single law enforcement officer that's here, really on behalf, I think, of Tiffany and the family as well, Mr. Nichols and Mr. Canal, for the work that's been put in for 25 years to finally get this taken care of. At this time, you can go with the bailiff. Oh, wait. Is there a?
Yes, Your Honor.
Sorry, we're going to do a victim impact statement. We'll go off the record for that. And go with the bailiffs until transportation to the Texas Department of Corrections. Go ahead. You accept your responsibility now that we saw it on a video.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count one before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so.
followed the direction. And there's no Miranda issue since she wasn't
Right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count one true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to punishment.
Yes, Your Honor. At this stage now that the state has offered evidence as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose. I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here, it's mine.
Okay.
Because of the prior thefts.
All right.
She's done with misdemeanor thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
No, ma'am, I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like, me being away from my kids right now is really hard, because they be with my mama, and my mama had dementia, and she...
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me, that if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. At some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
This is my responsibility.
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm going to tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, if you're in there doing it, you are the wrong person, right? So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to...
I'll get the other one worked out today.
Okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. That's not appropriate. First of all, pull them up. I know. Well, nobody wants to see your underwear, not in court and not anywhere. When did you smoke marijuana last? So here's the thing, you need to tell me the truth, because I'm gonna get a quantity amount, not just that you're positive, but I'm gonna get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are gonna be worse. So when did you smoke? When did you smoke last? Day before yesterday. So that's why you weren't wearing your patch.
No, really, I just, like I said, I'm on 2 different levels. I was already done doing my first one.
Right.
Now I'm on the second one. The first bill, when I was on, that's what my drug test. I figured since I wasn't paying the bill money anymore, I had to let drug test. They hadn't even been
I know, that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before court. That'd be pretty convenient, wouldn't it? So you're gonna have a drug patch today, within 24 hours. I know the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked, you understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still gonna give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones that'll help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched every 2 weeks like it's supposed to.
wear it properly. There's no going in and saying, well, it fell off, and none of that.
Even when I was on good, but I ain't never feel no good.
Okay, well, that makes me more concerned about your decision-making if you were doing well and then you decided right before court to go smoke, right? Okay, step in front of the clerk. She's gonna give you a reset notice. You need to get a lawyer hired as well before that next court date. Oh, sir. That's not appropriate. First of all, pull them up. I know. Well, nobody wants to see your underwear. Not in court and not anywhere. Does anybody ever want to see your underwear? Right? And you need to wear something nicer when you're coming to court. You went there to shoot either Christy and or whoever else. And luckily were not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. All right, you are Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously, entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have this person here for probation.
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address.
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
I would ask him a few questions if the state's not gonna call him.
I guess we will do.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. And July 21st, he did not show.
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300.
Okay.
Which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
Okay, thank you. Mr. Kimler?
Shouldn't the community service be concurrent in all 3 of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, you're correct.
So he would have 169 hours in each of the 3 cases?
Yes.
Credit, is that right?
Yes.
And is that so even though he was already on probation on 1 and then we gave him probation on 2 after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service?
Yes. Sorry.
May I proceed, Your Honor?
Yeah.
How long have you supervised him, Mr. Patton?
So I'm a unit supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
But you have some familiarity with him?
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he be continuing on probation, you would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexandra Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
Okay. But she was the one that was, I guess, directly supervising?
That is correct, yes, sir.
Do you have access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or?
Not that I've come across, no, sir.
That's what it is. No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you had been on probation since you were 18 and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's going to make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, from everything that's going on in the past, with me being shot and stuff like that. I was shot in my neck and my arm, so since then I've been having real bad PTSD, real bad depression, bipolarness. So, there's some days where I'm good, some days I'm not, some days I wake up on the wrong side of the bed from having nightmares, and some days I'm just as happy as I can be. So from that point on, at this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and aggravated robberies and all that. It's just a bad environment for me, and it puts me in a bad mood. Puts me, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MH&R, but I never went just because I felt like it was I felt kind of low, of thinking I would go to MH&R, because
stigmatized.
Yes, sir. So at this point, I don't want to go to jail or to prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and that kind of behavior.
I could ask him a few questions, Ron.
Sure.
I'm
Wait,
sorry.
best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday, 11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that for my ex-girlfriend, just, being dumb at the time.
No gang affiliation?
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant?
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
Oh, I always held a job. Even if it's working at Whataburger.
What was your last job?
Shoplifting Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out, you were a carpenter?
Yes, sir.
Scaffold builder, what were you?
We were doing woodwork, building decks and carports and lunch tents and that nature.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you had returned fire?
Yes, sir.
That's not what.
I understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it and I'm not trying to.
My understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot. You went there to go shoot Christy, which is your child's mother, right? That's not true? No? So did you mean to go shoot the 2 girls that got shot, Alexis and Taylor?
No,
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes, the 2 girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were gonna rob him, and in the course of that, there was a gunfight, but he wasn't going there to shoot anybody.
All right, well, that's.
He was going there for an illegal purpose,
That goes against everything that was said and everything that he agreed to back then, because.
That's correct, Judge. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and or Taylor might have been killed, but he was there to go kill Christy.
I didn't represent him on
Okay.
that, so I don't know.
All right. Anything else? All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact. And you can't claim that, well, I feel bad because I got shot by somebody who was defending 2 other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address always with these jail incident reports without having the opportunity to cross-examine the person that made the allegations. So I would ask the court to consider the fact that that's not subject to, those allegations aren't subject to the rigors of cross-examination. But I think that on Mr. Brady's behalf, struggling with depression is a serious matter, and I know, and I respect Mr. Smith's looking at this as a way somebody just volitionally, or somebody just deciding to be stubborn and self-centered and not complying, but depression is a serious problem. He has struggle with that. I think that's indicated by the limited mental history that we have. There is no new offense allegations in this. These are administrative violations. Of course, those are important, especially reporting. But because of the seriousness of these cases, I would ask that the court give him at least one more chance with the aid of mental health, maybe safety, but also as a follow-up if he gets out, to follow up with Spindletop, to address not only any substance abuse problems, but any underlying mental health issues that may contribute to the substance abuse and just his ability to comply and just to continue on probation.
All right, thank you, Mr. Kimler. So, Mr. Paredes, the thing is, you've been given exactly what Mr. Kimler is asking for. You've already been given that. You said it yourself. They recommended Spindletop. They recommended medications. You made conscious decisions not to follow through with what they knew was best for you, which is part of your probation. Everything that they say you should do is a court order. The fact that you are on a probation for possession of a prohibited weapon, like you said, from back when you were 18 years old, put you on a probation, 10-year deferred for that, November of 2016. Then we're back here, you're put on probation for 10 deferred on 2 aggravated assault causing serious bodily injuries in March of 2022 for shooting 2 girls. And you got shot in self-defense. And it appears that there's no real reason for me not to believe that that's how it happened for a number of reasons. No one else was charged with aggravated assault for shooting you. All the police reports, everything that went through in those pre-sentence reports previously that I have copies of, all makes it appear to be true that you went there to shoot either Christy and or whoever else. And luckily were not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. I feel like you've been given every opportunity. And when I look back on some of these times where I give chances like I gave you, it's very frustrating and a little embarrassing because it looks like I was not really thinking clearly then. I understand that these are drug allegations. You've been given opportunities to get help. I mean, you've been on probation since 2016 with every opportunity possible. So at this time, in cause number 16-24053, I'm going to, also based on the evidence presented today, I am going to find count 5 true. So that makes you pled true to counts 1, 2, 3, and 6. I'm finding count 5 true based on that evidence in each of the cases. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 20-35329, also find counts 1, 2, 3, and 6 that you pled true to those freely and voluntarily. Find them true. Also find count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. In cause number 20-35328, again, find that you pled true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Make a finding of count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case. All 3 of these will run concurrently, which means together at the same time. I am going to hand you a trial court certification. These were not agreements. You do have some rights to appeal. You can talk to Mr. Kimler about that. I need you both to sign and fill out the bottom, and you'll get a copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right. I'm sorry?
It was 7,
12 and 12.
12.
Affirmative finding of deadly weapon on both of the two cases. One of those is for him. Everybody's a comedian. Huh? I know, he's like, I'll take a break from this all day long. Can I go with him? Nope.
Good morning, Your Honor, babe.
We've even got the out of county come joining in the fun.
I heard the joke.
It's funny today. It was not so funny yesterday.
I bet not. Y'all were in the middle of jury selection.
Yes. You know how I am. My head went. Good morning. Are you Leonard Guillory? And Mr. Guillory, in cause number 22-40982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
Yeah, it was with a vehicle. That's at least what the administrative hearing says, but let me.
I haven't seen anything about it evading.
I think
it was only the.
My recollection was that it was evading on foot. I'm happy to explore it.
That's okay, let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. And the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response, reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly was
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
No, ma'am. Judge, it's just arguments.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Guillory had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case with the ag assault, understandably, it will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for either for the complaining witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than $200,000. A bond that high, a lot of bonds from the courts, it's hard, a lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or been going to court on that. My understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's obviously that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that.
Yeah.
So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause, it's not public.
Gotcha.
I'm sorry, Judge.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is. Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offensive burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it, and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information, because I don't feel like if that's going on, that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion, as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know, and we'll get a someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff. And we don't have punks like you acting like this and treating us this way when we're at our job. So Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge, I
the
think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm gonna do, but I'd be glad for you to do that as well.
Yeah,
Okay.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these 2 evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
Really? You're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No,
This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. You think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition, in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janesha Butler.
Janesha Butler?
Jamesh.
Jamayasha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her, through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. Good morning, ma'am. You're Connie Daigle?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Daigle, in cause number 24, DCCR 1738, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from July 5th of 2024. The indictment alleges you were previously convicted of theft March 29th of 2010, and then again August 24th of 2017. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? I'm sorry? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? I'm just looking, trying to see what this agreement is.
It's a punishment as a misdemeanor judge under 1244 of the Penal Code.
But it's a probation.
Yes, it's 1 year probated for
Yes.
6 months.
Yeah, we can punish it as a misdemeanor. My understanding is if you punish it as a misdemeanor, you can also punish it with probation, misdemeanor probation. That's my thinking is.
Oh, I don't know. I've never done that in all these years. Can we, for sure?
It's no prohibition against it under 1244.
But it's a state jail felony conviction, so it's an A. 1244A is the state jail felony conviction.
Yes.
With misdemeanor punishment.
That's right, Judge.
B is just reducing the whole thing. That's not what we're doing.
That's not what we're doing.
So it's 1244A. But if it's a state jail felony conviction, I don't know how to, I can't sentence her to 1 year in the state jail and probate it.
Well, we don't, I mean,
Oh,
county jail.
right,
No, we
county,
mean county jail.
yeah.
Yeah,
But I
that's
don't
the
think there was a
confusion.
line that said I
Yeah.
could do a county jail probate.
Yeah, it's not state jail, Judge. It should be county jail.
Okay.
Maybe I took it on the wrong line.
No, I'm just gonna mark
And
through
I-
it. We just
okay,
need to
I didn't
mark
catch
through
that.
it.
Yeah.
Okay.
Okay, so,
It's 1 year county jail probated for 6 months.
okay. It feels weird.
And I've never done it either.
But my understanding is punishment, it can be punished as a misdemeanor.
Right.
With no limitation on the type of punishment.
Right,
So why not do a misdemeanor probation?
okay. Okay. Makes sense. You're the one that has to do the judgment.
What Tommy's number?
I know,
Was there a
okay.
line that has county jail, like,
No, I marked through, well, there is
There is a
actually.
line that-
There
yeah,
is a
so I
line.
put
Let me
on the
do
wrong
that.
line, yeah.
That's okay. I'm
There's a
gonna
line.
change that. At least it'll read more clearly when we're looking at it and trying to figure out later when Anna's asking me what we did. Okay, so the agreement then is for you to be convicted of the state jail felony, but you would be punished under section 1244A of the Penal Code, which means your punishment would be 1 year in the county jail, but you wouldn't have to serve that. You would serve it on probation for 6 months. If you violate your probation, then you could go back to do that 1 year in the county jail. You understand?
Yes, ma'am.
Okay. And no restitution?
No.
Okay. Also, part of that probation is that you're not allowed in any Target store. You understand that as well? Okay. Are you a U.S. citizen?
Oh, yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Daigle is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of the state jail felony offense of theft with previous theft convictions. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code, but I'm going to probate that. You'll be on probation for 6 months. You are ordered to pay the $250 fine. You're ordered to remain out of all Target stores and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, if you do your probation correctly, your case here in court is over and you'll be able to serve that 1 year sentence while you're out on probation. And the other side of that, though, is if you violate any condition of probation, you can be brought back into court, your probation revoked, and you could go to Jefferson County Jail for that agreed time frame of 1 year. Do you understand? I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. You need to have a seat here in the courtroom. Probation's going to call you up to go over your paperwork when she's ready. She's sitting at that desk right over there, so watch for her to call you up there, okay? Good luck to you, ma'am. Thank you, Ms. Holmes. Thank you, Mr. Coleman. Ms. Holmes, you've also got Norris Gallo. Mr. Albritton, you've been here before. Why are you wearing sweatpants? You thought sweatpants was good to wear to felony court? You need to dress nicer when you're coming to felony court and pull them up as well. Did you get a lawyer hired?
I got laid off, but I'm back. I just got my job back.
From where?
You were moving too slow.
When did you get laid off?
Last month.
So you've been coming here since July. Who'd you talk to lawyer-wise? Where are these people?
Well, there's some of them there in Houston and some of them in Dayton. They come all the way down here though.
So you got laid off when?
They got laid off last month.
Okay, so, but you've had all these months before that I've been giving you time to get someone hired.
Yes, ma'am.
This is your last reset. Figure it out, get someone hired before the next court date. Talk to some more attorneys or pick the one that you're gonna go with, start making some payments, do something, okay? Step in front of the clerk. Someone's back there waving at me. I'm not sure if you have another. We're not.
And I will be responsible for taking him back and forth to his appointments.
The reporting part, he didn't have a ride. He had to rely on a ride share, and he didn't have a phone, so the phone that he used to call and set up the ride, that wasn't his phone, it was somebody else's phone number. So when the ride got there, they called that phone, but that phone, the person who had the phone was long gone. So he didn't have a ride to get the probation on one of those occasions. To his credit, he doesn't have any new offenses. He appears that he's telling me that he's got a job as a longshoreman. He's been working as a longshoreman at the Port of Beaumont. He's able to go back and get that job if he were to be released on probation. He would like a chance to do that. He's got a 12-year-old son who's currently playing basketball. He wants to go back and help coach his son in basketball and create a better life for him.
part of the issue, I think, is he's got, his father, I believe, has some kind of a restraining order against him to where he can't go back home. It had nothing to do with this case. It's just his father didn't want him back at the house. His father's been calling my office weekly telling me that he's welcome back at the home now, so he wouldn't have to be living in hotels. So the money part of it would be taken care of. He's just asking for another chance on probation and prove to you that he can follow the rules this time. I think at the appropriate time, he may want to say something.
Go ahead.
I want to read the letter, so.
Okay.
Good morning, Ms. Willis. I'd like to first off, I apologize to you.
Speak up, I can't hear you.
Good morning, Ms. Willis. I'd first like to apologize to you for not having my responsibility that the court said for me to have. I had trouble reporting for several reasons that I wish to.
You slow down and speak up.
I had trouble reporting for several reasons that I wish to explain to you now. The first reason, I missed my ride because I did not have a phone, so I didn't know how to meet. I didn't know to meet when they arrived because I used someone else's phone and they ended up leaving me. The second issue is I was standing outside of my door where I was staying. A man was stabbing my door with a knife for a reason that I don't know. So that scared me and gave me PTSD, and I did not know what was happening until I saw the man on the news for stabbing several other people. I was in fear of my life at the time. Next, I missed the inmate tomorrow meeting because I missed my ride again and tried to reschedule, but they said I already came in. So I had confusion on the phone that day, so the lady told me call them back the next day. Then I had to move to another room because of the stabbing situation, and I never got the chance to call that day. I had a drug test or alcohol, and I was, the next reason, I'm about to say, I failed the drug test for alcohol, and I was going to just be put on a 15-day freeze, but I asked to go to Walmart to a halfway house, and he got mad and unsuccessfully discharged me.
All right, thank you. Mr. Smith?
Judge, it seems like, just like probation officer states, he continues to put the blame on somebody else or something else. It's never his fault. He doesn't accept responsibility. He's already been to safety. He's given the tools. He's failed to be able to put those to use in his life. And we would ask for revocation and sentencing him to TDC for capital 6.
And Ms. Cole, thank you for being here. Is there anything that you want to add?
We're just at the court's discretion. As far as him reporting, his father came with him the first time that he reported, and his dad was actively his transportation to get there. He did provide me with a phone number where I was able to reach him at one time, and then he stopped answering. The MHMR, they set up his appointment for him through the OSAR drug treatment because he went over there and he missed that appointment. They even tried to call him. I tried to make contact with him several times. I called his father several times to get him to come in, and he did not. And upon talking with him at the jail to do the pre-sentence report, he still refuses to accept responsibility for his actions. So we leave it to the court's discretion at this time.
Someone's back there waving at me. I'm not sure if you have another. We're not.
And I will be responsible for taking him back and forth to his appointments.
Thank you, ma'am. Well, I mean, what is the, so there's some kind of mental health issue, but we don't know what because he never went to the evaluation. Is that correct?
He was instructed to go. I helped him make that appointment at one time too. He was instructed to go not once but twice, and he did not go. He was actually staying at a hotel literally about 15 minutes from probation. He could have walked down the street, and he just chose to disregard that.
Mr. Spencer, if this was your first probation, I'd probably feel a little differently, but you've been on probation twice before for felonies, and both of those were revoked. And then you were given another opportunity at a probation. And here we are after, yeah. All right, I'm going to find, I mean, yeah. You know what it takes to be on probation. You know what it takes to try to be successful. You've been given those opportunities. The fact that this is your third and I gave you that opportunity was already a big deal. And the fact that Mr. Smith did. I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find, is it a cap?
Cap of 6.
Sorry, it doesn't say. I need that. Those updated reports need to say that on that. Cap 6. Okay. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir. You can go back with the bailiff. Let's see. There's not much for you to argue here today, is there? You haven't given your attorney anything. Good morning, you're Lamone Yeoman Jr.
Good morning.
And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts 1, 2, 4, and 5. Does the state have any evidence with regard to the others, or are you ready to go forward?
No, Your Honor, I'm just ready to go forward.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the, because I believe you pled true, not true to number 7, which is failing to report. I do want to address those.
Okay.
I'm sorry, I meant that on number 6, the new firearm case, nothing's been brought over, nothing's been filed, so I have no evidence presented on that count.
Okay. Let me get that pulled up. You may proceed.
Would you please?
I'm sorry, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
It's Ms. Cole, right?
Yes.
And how long have you worked for probation?
A year.
And during your time of probation, have you supervised Lamone Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th, you've not seen him since?
Until he was arrested, yes, sir.
So is it safe to say that on April 11th of 2025, April 21st of 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required to see you or to the probation?
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report again?
April 7th.
April 7th. And have you were able to talk to him about the different reasons why he didn't report?
I called him actually on his birthday, and I told him you have a warrant, and he told me because it was his birthday, he was not going to tell me.
Are you aware of any time while he's, since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get those messages?
I called, I sent letters, and I called his mother. Okay. And his mother told me that he was aware of the warrant.
I pass the witness.
Another question for purposes of proving up count number 7, Your Honor.
Okay. Based, any witnesses or information about count number 7?
Okay.
All right, then, based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so, again, I've got the updated pre-sentence report as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter, this? It's
I did
from,
not show it to Mr. Nichols.
and take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to the page 1, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of that program.
Okay. I guess being kicked out is better than being absconded. Anyway, all right. Anything else?
That's what the PSI note.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in safe P. He did successfully finish the first part of safe P. The aftercare program is a part that he was kicked out of. He pled not true to count 1 as far as, I believe that counts as he was selling K2. What Mr. Yeoman tells me is that one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2, so everybody in that room was kicked out. And that really just started the downfall for him on the probation judge, because at that point he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the messages were given to him to report, he wasn't able to because he didn't know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, and as far as the possession and the weapon charge. According to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much for you to argue here today, is there? You haven't given your attorney anything to argue for you.
I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that safety program. And that's what he's asking me to give the opportunity to do this morning, is finish that aftercare program, possibly even due to those new offenses, one of them being weapon, maybe even consider sending him to ISF Cognitive to help him make better decisions. And if you had more questions about what happened at safety, Mr. Young is willing to talk about those.
So there was an ISF, okay, there have been 7 administrative hearings, 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally, what appears to be a week or 2 after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case of, while you're on probation for aggravated assault with a deadly weapon, you obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second. And then we're here again. I sent you to Safe P. And not only did you get kicked out of Safe P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances. And if you go back to his original PSI from 2019, from the 2019 offense, the ag assault, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct in that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate, Your Honor.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point, we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's gonna keep giving me probation. I'm gonna come in, I'm gonna write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 19-32846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of, which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the paper.
Thank you, Your Honor.
Thank you. Thank you.
We sit in there and we eat and we gain weight and we watch movies and it's a vicious cycle.
Judge, I filed
He was busy waiting his turn.
I was. Looking at my phone. I filed a motion to modify probation as well on another case that she has. We were having problems with e-file yesterday, so it may have been very late in the day. I don't know if it made it, but it's...
I received it this morning, Your Honor. I can tell you what it is. And we kind of discussed this with Ms. Simmons earlier this morning. Ms. Taylor pled a couple months ago on, I think, 2 other cases, and got probation. She was ordered to safety. Before she could get sent to safety, this case got indicted and they kept her here. This case was indicted about a month ago, first week in November.
Okay. Offense date of?
March, predates what we did before.
Predates it, okay.
It was part of the backlog of testing from the lab.
Yeah, and so the agreement on this one is?
To run concurrent with what she's doing, which, I think this is a 10-year deferred, concurrent with what she's already doing. Mr. Galmore's position is that since she's had to wait a few extra months in custody and not able to go to safety as ordered, he's asking that safety condition be switched to maybe ISF or something else if the court deems appropriate.
So what I would do at that point is it would get reset for sentencing and they would have to do a new substance abuse evaluation. If you want me to, I need probation's input. If their recommendation previously was for safety, then she hasn't received any treatment. I understand that she's been in custody, but that's not treatment. And so if she's going to get a probation on a possession to go along with that, there's going to be some treatment, and I would anticipate it would be in custody treatment.
And that's what my motion on the, motion to modify probation was, suggested was an alternative treatment program that just may be shorter. I think the real reason for the argument would be the fact that she is farther removed from her drug use at this point than it was originally considered.
I would consider ISF,
Well-
but I'm not going to do outpatient. I think we need something with 2 felony probations that's a little more intensive.
ISF would, the shorter ISF program would probably be about the same amount of time that was originally planned for her to be in custody anyways.
Right.
And so that was one of the requests
Okay.
that my motion made in the motion to modify. And then we left the treatment plan on this plea up to the courts.
So is there any reason to get even an updated pre-sentence report? I can just
No,
go
Your
ahead and
Honor.
do all of this.
She's been in custody this whole
Okay.
time, so there's nothing,
Sure.
nothing that's been changed.
Right.
I know of no major disciplinary problems or anything
I
like
don't- yeah.
that, so I would ask the court to go forward today.
Okay, all right, let's take care of the new case and then we'll discuss the modification. Then, you're Melissa Taylor.
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Taylor, in cause number 25, DCCR 1693, you're charged with a third-degree felony offense of possession of a controlled substance from March 9th of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for a 10-year deferred probation. Is there no fine on this one?
I'm okay with waiving the fine. Your Honor,
All right,
since
there
she's
would be
already
no fine on this case, and you would be required to follow all of the rules and conditions of probation, which, as you guys have said, is unagreed as to treatment, but that we've talked about. What I'm inclined to do is the substance abuse track of the ISF program. Is that your understanding? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Taylor is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I am going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You're ordered to follow all of the rules and conditions of probation, which include entering and successfully completing the substance abuse track of the ISF program. In addition, as your follow-up treatment, when you get out, you will be required to enter and successfully complete the JCDI program. So you're going to get out, you'll have all the tools. You're going to get tools while you're in custody. You're going to get out, you're going to have even more tools so that you can be successful and get off drugs for good, be a productive member of society, and not end up with felony convictions on your record and going to prison. And if you do all of that, just like we talked about in the other case, this is a great opportunity because you don't have the conviction on your record. If you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition in this case, you'll be brought back into court, you could be found guilty, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you, in that case, the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. Yes, ma'am?
May I speak?
Let me, hold that just a second. Let me take, because I'll get sidetracked and then I won't do what I need to do legally. So now, for probation, in cause number 24, DCCR 2311, I am going to grant that motion to modify the probation order to change that from SafeP to ISF, substance abuse with JCDI as aftercare. 24 DCCR 2311.
Judge, I think there may also be another probation that she's on, a different cause number.
I'm not sure.
I thought we pled her to a state jail and a
Can y'all look,
higher level
please?
felony. I just don't want, I don't want to get skipped over if there's another.
If she's on probation for more than that one, if there is another, and then the same order goes for all. If it was SafeP, that can be,
I know it's this one or two.
switch from SafeP to ISF substance abuse with JCDI as a, the problem is if it's a, do y'all think there's one? Because it might be the time that she's on probation could be an issue.
But I
Okay.
could be wrong.
Okay, we'll double check it. If she is, that'll be a condition. It'll be switched from SafeP to ISF also. Okay, yes, ma'am.
Yes, ma'am. So I have been incarcerated for the last 8 months in Jefferson County Correctional. During the last 8 months, I've had a trustee position for 6 of those 8. There are no programs for rehabilitation for women like myself that spend 8 to a year incarcerated. There are none. The completed literature that I put down, I went out of my way to obtain that, get those shipped into me, to reach out to an outside sponsor to review my packets that I went through. I have, whether you go to a 9-month program, a 6-month program, or a 3-month program, the desire of the individual to change and putting these into application are what actually creates lasting change. Otherwise, they're just books that I've read.
Sure.
If you can ask me anything about these books and I can tell you how I've changed and how they've changed me and what they've done. I realize that my addiction is a terminal disease that will kill me. And it is a lifelong recovery process. And that if I don't completely abandon myself to my higher power in a recovery program for the rest of my life, that I will end up in prison or dead. I don't have any more options. I agree that I will most likely learn something from ISF. I will learn from any program that I'm ever put against. But I am begging you with the effort that I took, seeing that there's no options for female inmates other than an AA program every other week at best. We sit in there and we eat and we gain weight and we watch movies and it's a vicious cycle. I understand the triggers and what made me relapse. I have a phenomenal support system, and I am willing to go so far to say that if you give me the COLA program, and if I fail, take this all away and put me in prison for 5 to 10 years. Don't have it as an option.
Mr. Nichols, so
Big red letters on
so
the
here's the
file.
thing, Ms. Taylor, the words that you're saying are, no, I mean, I can tell that you're sincere. I hear people say those words somewhat often. I wish more. Sometimes I feel like they're sincere, others I don't. I agree, there are not programs because jail is just a rotation of coming and going, and it's hard to get programs going because by the time someone gets started, they're probably leaving, and it could be better. I appreciate what you've done. I'm inclined, but here's my fear, is that I don't want to do what you're asking and set you up for failure. So if I do what you're asking and you violate, there's going to be a notation about all of this. Mr. Nichols will remind me, probation will remind me, and there won't be, okay, now I need SafeP. Now I need ISF.
I'm that dedicated to my recovery.
You know, I usually have a pretty good memory for these things, Judge. If the court wants to give her that shot, I don't want to have to revoke her. I want her to be successful. I've read what she provided the court. I know it's impressive, the work she's done for herself while in jail. I'd hate to see it all fall apart, though. I mean, I think the case she's on, other case she's on probation for is assault on an officer. And I know there was at least one state jail.
I do have, so 24 DCCR 2177 is another, she's on probation for. There is another probation. And so 24 DCCR 2177, so whatever I do to modify conditions are going to be the same on those. So I guess what I'm gonna do, Ms. Taylor, is I'm gonna give you this opportunity. It's 100% up to you to take it, otherwise you have 3 felonies that you're gonna go to prison for. And here's the thing, if you feel like you're slipping and you need more, and you go say, I need SafeP or I need a ISF before it ends up with me, that's one thing. That's a hard decision to make. But if you're truly committed to it and you feel yourself slipping that you need inpatient, it's gonna be up to you to make that decision to ask for it. If it gets so far that you're here, it's gonna be too late. All right, so then I'm gonna modify the conditions of all of those probations, including the new case, to order that Ms. Taylor enter and successfully complete the JCDI program and not have to go to ISF or SafeP in any of them. So take advantage of this. I did everything else.
I think so.
All right, good luck.
Yes, ma'am.
There's two old probations, the 2 prior ones, and 1 new one. So we've got 3.
You need both numbers, Jody?
You got it.